A court upholds an invasion of privacy under the Fair Credit Reporting Act. Hi, this is Consumer Protection Attorney Bill Clanton, and in this video I'm going to discuss a case out of Ohio where a plaintiff alleged that credit associates in TransUnion conspired to invade her privacy. Now this case, the Hopper case, there was a decision in it recently. It's a case that I'm following. And Hopper, her lawsuit, Tara Hopper, sued Credit Associates and TransUnion, stating that they had invaded her privacy. Now, Credit Associates, we made a video about them previously. You may have seen it. Credit Associates sent out a mailer that looked a lot like this. And it said at the bottom, pre-screen opt-out notice. This is a pre-screen offer of credit. It is based on information in your credit report, including that you meet certain criteria. This is not a guaranteed. This offer is not guaranteed if you do not meet our criteria. If you do not want to receive these offers from this and other companies, call consumer reporting agencies toll-free at toll-free number, or visit the website optoutprescreen.com or write TransUnion opt-out request. So Credit Associates got Ms. Hopper's information from TransUnion, and so she sued them because there's only a few times that there's a permissible purpose to get somebody's credit report. These promotional inquiries, if you look at your TransUnion credit report, you'll see hard inquiries, you'll see soft inquiries, and you'll see promotional inquiries. That's what these promotional inquiries are. They're soft pull. They're not hard pull. They don't ding your credit, but they are selling your credit information to people who have a permissible purpose. Now, TransUnion and the other bureaus are required to get a statement of a permissible purpose where whoever is getting that information will say that this is for a permissible purpose. So I don't know how exactly Credit Associates got this information, if they got it directly from TransUnion or if they got it from a reseller. But the plaintiff, Ms. Hopper, alleges in her lawsuit that TransUnion is a credit reporting agency and that and a consumer reporting agency. And it's in the business of supplying consumer reports, which are sometimes called pre-screen lists, in the debt relief industry. A pre-screen list contains the identities of individuals with certain factors bearing on creditworthiness, often including debt balances, information about creditors and debt, often known as credit trade lines, high interest rate debt, and or unsecured debt, amongst other factors. Such pre-screen lists constitute consumer reports because they are written, oral, or other communications of any information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. And that language is taken straight out of the 1681, the Fair Credit Reporting Act. So a permissible purpose under the Fair Credit Reporting Act is making a firm offer of credit. You may have seen statements come to your mailbox from credit card companies or banks offering credit cards saying you've been pre-approved. That's a firm offer of credit. A firm offer of credit is one that will be honored, subject to certain exceptions, if the consumer continues to meet the criteria that was used to select the consumer for the offer. So they have to verify. You call in, they verify your information, and then you're issued the credit card on the terms that were sent to you in the mail. That's a firm offer of credit that is a permissible purpose for the pre-screened information. Okay, so Credit Associates, debt settlement services, credit repair services is not a permissible purpose under the FCRA. And Credit Associates requested this information from TransUnion or from a middleman between them and TransUnion, and I asked for people who have significant debt or who are far behind on their debts, and basically they can fine-tune this criteria so well they can get the maximum return on their mailing. Their mailers that have this information, like the one I put up here a minute ago. So they can they know all the parameters, all the amount of debt, and the number of outstanding debts, and the age of the delinquency, and all that kind of stuff to get the maximum return on those mailings. So they give those parameters to TransUnion, and then get back their list of names and then send out that letter. And there's a couple of follow-up letters they sent too. So according to Ms. Hopper's lawsuit here, using and retaining pre-screened lists to send solicitations to marketing debt relief services is not a permissible purpose under the Fair Credit Reporting Act. Defendants, TransUnion and Credit Acceptance, or Credit Associates, acting in concert in an agency relationship and or individually mailed and or delivered thousands of direct mail solicitations to Ohio citizens, including Plaintiff Hopper and the putative class members. So Hopper filed this case as a class action because the number of letters that were sent out, thousands of letters, and they filed it just to address the just to Ohioans who received the letter. So they sent these form letters. Hopper never authorized Credit Associates to obtain her credit report. Now, if she had authorized them, then they could do this free, willy-nilly, whatever. They have her permission, but they don't have her permission, so that's another key element. TransUnion and alleged TransUnion failed to exercise due diligence or verify who the end user is, which could have been done through reasonable effort. Credit Associates, I'm sure, has these lists. They could have supplied them to TransUnion, but TransUnion didn't do a thorough investigation of who was getting these letters. Okay, so the class is defined as Ohio citizens on the pre-screen list defendants obtained, used, and or provided from January 1, 2027 to the present for marketing debt relief services. It's a pretty easy class definition. And so as this case progressed, and as is the case in lots of class actions, the defendants tried to get the case dismissed. And Credit Associates filed a motion to dismiss, and it was denied. And that happened, let me see the date on this order, on March 29th, 2022. So this is pretty recently. And let's go through the court's opinion and order dismissing Credit Associates' motion to dismiss, or resolving that motion. Okay, so it goes through basically what was alleged in the plaintiff's petition here. Importantly, it says Ms. Hopper avers that she did not authorize TransUnion or Credit Associates to request and or provide her private financial data to send her solicitations. Okay, so there's no authority to do that. She further claims that numerous other Ohioans received these solicitations without applying for any services, without giving Credit Associates and TransUnion authority to access and use their private information for any purpose. Okay. The court goes on to discuss the Fair Credit Reporting Act, and to qualify as a consumer report, the information must bear on at least one of the following factors: a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. In the present action, plaintiff alleges that the information and filters utilized to acquire the information bear on all 7 of the factors, including the total unsecured debt balance. Okay, and so the Credit Associates argues that the plaintiffs improperly used the phrase consumer report or credit report, and the court says this is because Credit Associates agrees with plaintiff that the information obtained about plaintiff and conveyed to Credit Associates on a pre-screen list technically qualifies as a consumer report under the Fair Credit Reporting Act. Thus, the parties are in agreement that plaintiff has sufficiently alleged defendant's actions violated the FCRA. Defendant maintains, however, the information obtained is not invasion of privacy constituting an injury in fact for purposes of Article 3, which is a separate inquiry from whether the Fair Credit Reporting Act was violated. Now, this Article 3 is Article 3 of the Constitution, where there has to be a concrete injury, not a hypothetical injury, but somebody has to actually have been harmed to bring a case. There is a Spokio case that we're making a video about from 2017, I want to say, let me see, 2017. So Spokio says that, 2016, excuse me. So Spokio says you have to have a concrete injury to have a violation of concrete and particularized is the language from Spokio. And they say in Spokio that if, incorrect zip code is an example of a harm that cannot be significant enough to bring a lawsuit about. And so all the lots of the debt collectors and some of the credit reporting agencies and furnishers try to rely on Spokio to say that this is a speculative injury. It's not a real concrete injury. And that's what they go to do here. This gets into some pretty heavy legal stuff, so I'm going to gloss over that for the moment. But the court's reasoning ends up here. In the incident analysis, plaintiff has sufficiently alleged the intangible harm of invasion of privacy of a type that has a close relationship to harm that has traditionally been regarded as providing the basis for a lawsuit in English or American courts. Misuse of credit reporting data is the harm the Fair Credit Reporting Act was designed to prevent by restricting access to consumer reports to permissible purposes as explained in detail herein. This is the harm that plaintiff has alleged here. Courts have traditionally provided an avenue of relief for alleged violations of privacy. Thus, Ms. Hopper has alleged harm having a close relationship with the causes of action recognized as a traditional basis for a lawsuit. All right, so the court says that she's got a case, and it goes on to say, Credit Associates does not dispute that the plaintiff has alleged and that it did not make a firm offer in accordance with the requirements of the Fair Credit Reporting Act. Okay, and some more good language from this opinion. Ms. Hopper alleges Credit Associates sought pre-screened lists by identifying Ohioans based on certain factors bearing on creditworthiness, including debt balances, information about creditors in debt, high interest rate debt, unsecured debt, credit scores, and credit utilization rate, among other factors. These allegations are simply not procedural in nature, such that they would violate the FCRA in only a hyper-literal sense. In passing the Fair Credit Reporting Act, Congress identified and elevated certain intangible harms that meet the concreteness requirements, such as an invasion of privacy and the misuse of consumer reporting data. Here, Hopper sufficiently alleged both. Therefore, plaintiff has shown she meets the requirements necessary for constitutional standing, and the court denies Credit Associates' motion to dismiss. So these are some very smart attorneys out of Ohio that brought this lawsuit, and congratulations to them on getting past Credit Associates' motion to dismiss. It is some great Ohio attorneys. Jeremiah Heck, one of them, with Luftman, Heck and Associates. Anyhow, if you have run across this Credit Associates letter, looks like this. It has some language about TransUnion at the bottom. You may have a similar case. In fact, you likely do. And if you're outside of Ohio, then this class action does not apply to you, and you would be free to bring your own lawsuit against Credit Associates and TransUnion. If you need help finding a Fair Credit Reporting Act attorney, give us a call. We're licensed in Texas, and can help you find attorneys who are members of the National Association of Consumer Advocates all over the United States. Thanks for watching this video. I appreciate your subscriptions, likes, and following us so that more folks can find out information they need about how their rights are being invaded and not respected. Thanks again.